Send the poster to the school of law group. Entry fee to that virtual session will be 200 shillings.
200 shillings only. So love to welcome Job and give his remarks.
Good afternoon. You are welcome here. Feel at home. You want to drink from the real source. Thank you.
So we have various club leaders and various events coming on board. We have Kulsa, Tennessee, Sitarosa, Boishi. So I want you, the first years, kindly, I want you to know your club leaders so that you can choose your favorite club to join. There is a Kulsa, there is a Human Rights Club, there is a KUN. Kindly those leaders, Amnesty International, Stella, who is she? Stella Kimani, Audrey. Any member from Amnesty? Yesterday we had a debate for Amnesty. Oh, Claudia. You can come. Sit, I'm waiting for you. Susan. KUN, Rahema, Jackie. Come on board. Which other clubs? Human Rights. Wakili wa watoto, Zakaria Maina. Good Society. Fidel. Say one time, please. Any representative from Society Club? Adman, can come on board. Oh, yes. So, 1 minute to each.
And also I'd like to thank those who joined us for the first mock debate last Saturday. I don't have all your numbers, so thank you. Thanks so much. And there's a second mock upcoming in November and even more events this October and communicating every sure to know your
Good afternoon, everyone. I'm Chief Utino Lusana, Secretary of Society. I would wish to welcome you all to the Mood Society Club. Mood is the best place to be. It's the best place to advance our advocacy skills. Those who joined us in the past sessions, this semester, we've done a lot. We are having 3 moods. One is going to be in Tanzania in 2 weeks' time. One is going to be in Daystar next week. In another one, natural justice, that will be confirmed in a few days' time, but we have done the internals. We are still having more that we're going to do this semester. Therefore, we welcome you all so that we can advance our advocacy skills as lawyers. Thank you. Oh, my chair is here. Let us say hi.
Hi guys. Vice Chair of Society, and I invite our first guest to join our society. My secretary is already talked about it. Welcome.
first one is under the research hub docket of the Mutual Society, whereby we'll be holding research hub training. And research hub training next week on Wednesday. Welcome you all to send your official poster. For those who attended the research hub training between last semester around March, so our research will also like how to coordinate legal profession also exam application person today to find other materials to make that application. So you understand
team just come prepared, go and research for that topic. I had already appointed some few individuals, and particularly first years. Our first years, I was quite impressed because it's your first time and I've got a representative from you. We are having one of you as a panelist, which has been digesting that case as well, alongside the other panelists. And so we are inviting you guys to come and participate on that particular day. On top of that, I would like to urge all of us to register for that particular club, and during the club, let us all fight for the rights of this country. Thank you so much.
Okay, thank you so much for the club representative. And right about now, we want to usher in our judge. And I kindly request you that you keep your phones on silent mode, please. And when the judge enters in, kindly be upstanding. You know the protocol that is being observed in our courts. So when the judge enters, kindly be upstanding. I'd also like to recognize the presence of the FDU chair, Mr. Robinson. Stand and greet, please. Salama sana. So in less than 30 seconds, we hear. Thank you.
Request Joy Kanano to come and lead us in prayers.
Let us believe and pray. Father God, we thank you for the gift of each and every one who's here. We thank you for the gift of the dedication that has come. We call upon your name that your presence will lead us for this meeting, for this talk. Let your presence go ahead of us, to guide us, to protect us, to go forth and lead us in what is ahead. Let your presence guide us, let your presence guide the speakers, let your presence guide each and every one here for the grace of your name. In Jesus' name we pray. Amen.
Okay, now have our seats. Good afternoon once again. Good afternoon. It's a great moment that we have this afternoon. As a school, we are very proud that we have this opportunity. So at this time, I want to welcome our Dean, our Able Dean, Dr. Wycliffe, to take over from me. Karibu sana.
Thank you very much. Good afternoon, everyone. We are happy to have this talk. For now, we will not say much. I know there will be a session for us to talk. In the interest of time, I would like to invite Deputy Vice Chancellor, Asa, Professor Nduru, to give a word, and then thereafter invite the Vice Chancellor. Karibu sana.
Learned friends, all protocols observed, I greet you all in Jesus' name. I want to take this opportunity to, especially on my own behalf, as the DVC ALSA, the head of division in academic affairs, where I think this talk is being delivered, to welcome the Supreme Court and his entrance to Chuka University. I want to thank God as well for this opportunity to be together in this manner, because it is not always that we have a Supreme Court judge seated with us in this manner. This is a great honor, and I feel it's a great prophetic achievement, because, Your Honor, this place is a prophetic place. It is the only place that has ever been prophesied on earth before it existed. Having wealthy have been bands of men. But this place, in 1951, God led one prophetess to Kwasi. When this was a bush, there was only a small church that had been established after the first founding missionaries in Togoria, and others having come and preached here. One of the first adherents to Christianity, Professor Jerusa Kanywa, led by the Holy Spirit, prophesied that this place will become a mountain of academics, where birds from all over the world will come and perch over the trees growing upon this mountain, and they will eat of the fruits of these trees, and then they will be okay and fly back to their homelands. And so when we see you here today, we consider the birds are still coming, and they are perching, and they are eating of the good fruits. One of the trees that is growing upon this mountain is the tree of law. We have a school of law here, and we have the fruits of the degree of the Bachelor of Laws in Chuka. We have students that have come from all over, and they are schooled well in Chuka. They have been inculcated into being legal minds of repute in Kenya, and we want to believe internationally, because from where I stand, they have competed very well, especially in the moot courts in the country and over, even in East Africa, and they have come back with trophies. So that testifies to the competency of this mountain to actually feed the law minds that will come from all over the world, much here. And so your being here is a blessing. We want to appreciate God and thank God for you to have considered it worthy to come to Chuka University and deliver a speech here. You are the first legal mind from the floor of the Supreme Court that has found it worthy to come. So Karibu Sana, we celebrate you as being historical in that you are the first to run here. So we are so grateful. And so I don't want to go very much. I can talk a lot, but I would want to say thank you and appreciate you so much. Thank you for considering Chuka the place to be today, because I know you have a busy schedule, but you consider you agree to come and with us. We are eager. We look forward to listen, to hear from you, and learn, and look forward to actually being better legal minds as we are inculcated, especially from the best of the land. Karibu sana. And with that, I want to welcome my colleague and the acting Vice Chancellor of Chuka University, Professor John Kindiki, to place the occasion.
Let's give him a better clap. Our distinguished guests, Justice of the legal fraternity from Chuka, who are with us this afternoon, the management team from Chuka University, the dean and the members of faculty, including students, ladies and gentlemen, good afternoon. God is good and all the time. We thank God for this opportunity that God has given us, particularly to be here at this particular moment. And I believe as a Christian, it was decided by God long time ago. I don't take things for granted that today we have the honor of having with us the judge from the Supreme Court, Honorable Justice Ouko with us. This is historic for us as Chuka University. We thank God for that. Sir, we want to take this opportunity to say we are greatly honored that to have you here, because your speech today will go a long way in mentoring these students to translate theory to practice. See, what lecturers say in class and in lecture halls is slightly different, but not quite, but slightly different, because it requires some experience when it comes to practice. That's why, after graduating with a degree of law, you go to school of law, and they also get their qualification, but you require to practice. And now, today, with us, we have one of the chief practitioners with us, Justice Ouko, because to be a judge of Supreme Court is not something easy. You have gone through the ranks to reach that apex of justice in this country. And my plea is that for the students, we are pleased that whatever we are going to get today is It's something that is going to mentor our students, give them insights about theory and practice. It's a great honor for us today to have you, sir, here and to give your speech or your lecture to us. And we are all going to benefit as members of Chuka University. Today, our Vice Chancellor, Professor Henry Mutebei Ntokiu, is not with us. And that's why today I'm the acting Vice Chancellor. And I think I should have started by saying my name, but I assume we all know each other. But my name is Professor Jonah Kidiki. My substantive role in this university is the Deputy Vice Chancellor in charge of Administration, Finance, Planning and Development. But my Vice Chancellor is with us, although he's not present today, and he has passed a very warm welcome to you and your team, that your presence here is not in vain, but it will go a long way in helping Chuka University and particularly School of Law. So I'm not going to give a lecture because a lecture will be given at the appropriate time. Mine will going to welcome you, sir, in this very important meeting, and also invite the members of Chuka University that we welcome our legal minds with us today and the judge of Supreme Court in this country. So I request, maybe from your side, sir, if you allow, if I mistake the titles, I need to be correct. Chief Justice, Magistrate. You are not a lawyer. I must get the correct title. The owner of the Magistrate of here, the law court in Chuka. Chief Magistrate. She's the Chief Magistrate, Chuka Law Court. Have I got it right? Correct. Madam, you are most welcome to follow the protocol and also invite our guest of honor this afternoon. Thank you and welcome.
My Lord, Justice Oko, and my colleagues who are present, the faculty, law faculty members who are here, and students, good afternoon. Good afternoon. It's not my first time here. I believe a number of you have interacted with you. Is my name, for those who do not know me, my name is Joyce Gandani. I'm the Chief Magistrate from
personally, I'm happy to be here again to interact with the students here, and judge the students here. Quite a number have had to do their judicial attachment in court. So whatever they are telling you, that the best legal minds, I can confirm it's true. In fact, the caliber of students we have been getting here, they rank higher even, if I can say, than UN, another university. That I can confirm. We were very surprised by that because we thought it was a new faculty, but they actually have quality students. So we are
quite delighted this afternoon that for once I've driven to this university. I've passed on this road very many times. I served in Meru locals for nearly 3 years, so this was my route to Nairobi, nearly twice a month. I also want to believe what the organizers saw on the road, also the name Hanwa, and I didn't relate to him because I live in B, from this area. Being worship of the prophetess, I had to see that we have people coming here from all over the country, from the region, perhaps from internationally. That she had foreseen all this, that they come here to pick lessons to go and spread out there. And I believe she must have also foreseen me coming here today. Wow. Because I was showing off to the acting Vice Chancellor that perhaps I'm the first Supreme Court judge to come to Chuka. But I put a caveat that that may not be entirely correct, because I may not know whether my boss who comes from around here has passed. So I will be corrected. If she has, then I'm the second one to come here. If she hasn't, then I'm the first. So if she comes next, she will be told I'm the first one. I also want to regret that we ought to have had this lecture earlier, but due to closure of the university at the time I planned it, it didn't take place, and I really want to apologize for that. As part of our 12th anniversary as a Supreme Court, we are actually this year 13 years old. We are still not, we are still children. 12 years is a child of 10 years. So we are still crawling, standing and falling, making mistakes. So when we held our anniversary to celebrate our 12 years of existence, we decided to bring in new innovation to the court. We had, before our big conference that took place on the 4th of November last year, we held public lecture circuits, taking us to most faculties, but mainly within Nairobi, a few outside Nairobi. We held moot courts, which I'm pleased we participated in, and also we did community service. So we also got involved in community service, where we helped the less fortunate members of society as a court. And so it's now a policy that is now described in our annual calendar that we hold these public lectures. Some of us, among the 7, have done as many as 4. I think this is my 3rd. And if there are medals to one, those who have done more will win that medal. I'm not competing, I'm just doing my bit. I was going to come here anyway. And so, as I said, we are pleased that you took part in the moot court competition, and we also hope and pray that you will be able to take part in the one that is coming this year on the 12th, between 12th and 14th of November this year, which will be part of the 14th World Conference of International Association of Refugees and Immigration Guides. It's an association that is chaired or presided by one of us. It's an international association, but the president of that association is one of us in the Supreme Court, Mr. Decisis and as one of the speakers said, I don't know whether it was in the boardroom, we have confined these lectures to faculty in Nairobi, and we think that there is much more to be gained by going outside Nairobi. So I'm quite pleased the Supreme Court went to the faculty. And so the reason why we think as judges that it's important for us to interact with students and the public generally is because the law and lawyers today play a great role in our society than in the past. And that resolving all types of disputes and other grievances have really grown over the years. And in Kenya, nearly everything attracts litigation. I worked in Meru, and I'll give you an example. It was a very, very common thing in Meru law courts, in the High Court. I mean, the court was always like this, every day of the week. Always like this. And sometimes there's one case that has attracted the whole village. And so you ask, what is happening in the village when you're all in court? Who is taking care of our cows and stuff? And so one judge from here, who was in private practice, a prominent man, told me a story of how one of his clients went to his chambers while he was in private practice to instruct him to sue his neighbor over a goat that had trespassed on the neighbor's land. The goat disappeared. The client didn't tell him whether he ate it or it just disappeared. But the owner of the goat wanted compensation. How much? 3,000 shillings at the time. So the judge in private practice then reached out to his wallet and said, no, we can't waste time in court. 3,000, I'll just give you, maybe I'll give you 5, and you just go home. And the client said, sorry, if that's the kind of practice you are doing here, I'm looking for another lawyer. Because for me, he must learn a lesson. So master him to court. So that's the kind of world we live in. And it's not just in Meru. You will find all manner of litigation in our courts, some of which really is a waste of court's time. But those who bring them insist on being heard. And so today, Kenyans really do not have any forum from where they can learn the law, where they can be told of their rights, other than many times I'm sure you watched on TV, experts, constitutional lawyers, trying to break down events in the country. But if you go behind those people who are always on TV, apart from a few, others will never find a classmate in Kenya, meaning they haven't gone to university. You can't find a track record at Chuka University, law faculty. You will not get them in any university in this country. But those are the ones who are breaking the law down for us. And so we thought that as judges, and really not just judges, all of us, even lawyers in private practice, really must be under some duty to share their knowledge with people who need to know. Of course, for us as judges, we have to know our limits when we go out to talk to the public. We do not talk about matters that are live before court. We do not talk about matters that are likely to come to court. So we have to be very, very careful, and that's why perhaps today the topic that was chosen for me about Decisis is a strange one, so that there is no way I can veer off and talk of one time or 2 times. As I was coming, somebody posted in a WhatsApp group about this nature, and somebody asked me what it means, Decisis, and somebody in the group did a quick research on Google and posted the answer. And so this is quite technical. The acting Vice Chancellor will bear with us, and the DBC, and those who are not lawyers, but I'll make it very simple so that we can all follow. So I look at 7 aspects of Decisis. Again, how you pronounce it. Some people pronounce it stare. There is no stare. It's not English word. It's Latin. Latin is just read like Swahili, starring Decisis. So I don't know why Decisis now sounds like English. But I'll talk about the history, how it has evolved. I'll talk about where it originated from, the common law of England, and examine how today stare decisis operates in Kenya. I'll also discuss the type of president and the dimensions of stare decisis. We'll also be looking at the practical application, which is really the topic of today, of stare decisis. And finally, we'll give a reflection on its relevance in Kenya today. And of course, I will comment on some remarks. So, but to get to know where we are today, it's important to go back to follow how the Supreme Court has evolved, because eventually we talk about stare decisis in relation to the Supreme Court and other courts. And so the Supreme Court has been there before. You may not know, maybe those of you who are reading history may know that the Supreme Court existed before we got our independence, when we were in a colony in 1920, through what they call the East Africa Order Council, which established a four-tier judicial system, starting with the subordinate courts, which were at the bottom, that's like today, where we had African courts, these were for natives. We have Cadiz courts, also for Muslims who are natives, and also they had European courts for the settlers. The second level from the subordinate court was the Supreme Court. So the Supreme Court has always been there. Of course, I'll explain at what point it disappeared before it came back in 2010. So the Supreme Court was the second level after the subordinate courts. And then after the Supreme Court, above it, we had the East African Court of Appeal. This was a court of appeal for East Africa, but served the countries in West Africa. Then the final court for us in this country at the time was the Judicial Committee of the Privy Council, which was based in the UK. And so in 1963, the Independence Constitution formally established the Supreme Court in our own constitution. The Supreme Court was again recognized in 1963. Later on, the Constitution was amended and established the Court of Appeal. The Court of Appeal became the top court, and Supreme Court became the court below it. And so that tells you that the Supreme Court was always the current High Court. It was called the Supreme Court. So that amendment brought in the Court of Appeal, but we did not operationalize the Court of Appeal. We still rely on the East African Court of Appeal. And so further amendments came in 1965, which brought into very significant changes. The first one was the Supreme Court was for the first time renamed High Court. The second change that this amendment brought was that it abolished the appellate jurisdiction of the Judicial Committee of the Privy Council. The Privy Council stopped hearing cases from East Africa, and the East African Court of Appeal remained the apex court at that time. But when East African Community collapsed in 1977, then the East African Court of Appeal also went. And so we then went back to our Court of Appeal that had not been operationalized at that time. And this remained the top court, the apex court, until 2010, when the Constitution was promulgated. And so the Supreme Court becomes the highest court in Kenya, and that history is important And of course, you all know how the Supreme Court and how generally the Constitution was conceived. You remember the violence that came with 2007 elections. Remember the Kriegler Commission. Remember the report by Kriegler to the effect that Kenyan people had no trust, had no confidence in the electoral system, in the judicial system. That the courts were compromised by the executive, the courts were corrupt, the courts were inept, and so they recommended that there be reforms in the judicial system. The Kenyan people were also concerned in the manner courts were interpreting the law, that if there was a dispute between an individual and the state, or a local a simple person in the village and a powerful person in the society, the result was known even before the case was heard. The Kriegler report also noted that the human rights provisions in the Constitution were just provisions in paper. The courts refused to interpret those provisions. The courts refused to apply them. It should interest you to know that under the old Constitution, under the Bill of Rights, the Chief Justice was given the powers to make the rules to operationalize the part on Bill of Rights. And the Chief Justice at the time had a matter where somebody had been abducted, somebody had disappeared, and an application was made for habeas corpus, and it went before the Chief Justice. In the old Constitution, the Chief Justice sat both in the Court of Appeal as well as the High Court. So the matter went before him in the High Court. The story we cannot deal with this because there are no rules to operationalize these rights. Who was to operationalize the rules, to make the rules? The Chief Justice himself. So Kriegler said, with all this happening in the courts, we need to bring some reforms. Hence, the 2010 Constitution, which was popularly supported through a referendum, if you recall, and the Supreme Court was established as the highest court. So the Supreme Court has 5 areas of jurisdiction, 5 areas under the Constitution, and normal. Unlike other courts, it has the narrowest jurisdiction, and that's why a lot of people wonder what the Supreme Court judges do after hearing the presidential election. They think they only go to court once in 5 years, and you can't blame them for thinking so, because every other day we sit, they do not see as in the public there until there's a presidential election dispute. So the first jurisdiction of the court is original jurisdiction, where we hear disputes arising from the presidential election. Then we also have as number 2, appellate jurisdiction. We hear appeals from the Court of Appeal. But these appeals must meet 2 tests. The first test, that the appeal you are bringing from the Court of Appeal must involve the interpretation and application of the Constitution. And the second link is that it must be an appeal that raises matters of general public importance. So we have the appellate jurisdiction divided into those 2 links. The other one is advisory. Advisory opinion, we advise the state organs, we advise national government, we advise county governments on issues concerning county government. So you can't wake up one day and say, I want an advisory opinion from the Supreme Court. You have to meet that threshold, that you have to be a state organ, you have to be a county government or national government. So it's not an open-ended advice that we give. And there are many other parameters that must be met. The other jurisdiction, the fourth one, is validity of the declaration of state of emergency. So that if the President were to declare state of emergency, any Kenyan can come to the Supreme Court to test the validity of that declaration. This is the only of the 5 jurisdictional areas, the only jurisdiction we have not exercised, and we do not look forward to the final one is about judges who are being removed. When a judge misconducts him or herself, there's a process of removal. The President appoints a tribunal. If the tribunal finds the judge has grossly misconducted himself or herself, the recommendation is to be removed. So any judge who is aggrieved by that decision of the tribunal doesn't go to the High Court, but comes straight to the Supreme Court. So that's the last area of presumption. So how does Decisis apply? Now, just to give you 2 examples of 2 people, one in Chuka, another one in Wali. Same facts, same law. They go to court. One goes to Chuka law courts, and one goes to Wali. On the same law, on the same facts, but they get different outcomes. So one, the chicken has been stolen by X. And also one, my chicken has been stolen by Y. Why would there be different decisions? This is why we want to explain why Decisis is very critical, because it also restores public confidence, and it can also erode if it's not used public confidence in the judicial system. And Decisis, for those who are not lawyers, it simply means to stand by things decided. Stand by things decided. So that if I decide something today, I'm supposed to stand by what I've decided. Because if I change my mind tomorrow, what stops me from changing my mind next week? So it is like a that way. You cannot go left, you cannot go right. Stand by things decided. And it's one of our cornerstones in our judicial system. So that like cases are treated alike. And the citizens can anticipate clarity and decisions that are consistent. It reflects the legal principle that once a court has laid down a legal rule in deciding a case, future courts should follow that rule when deciding similar cases. The origin of this doctrine lies in the English common law tradition, which, as you are aware, was enacted in our Literature Act, but it is something that started in the 13th century, where decisions were recorded in what they call yearbooks. So whatever decision that is made in the 13th century, they wrote them in some book. So that future judges will just look at that yearbook and know if it is a case of land, you go to that yearbook and you get a similar case. And that's how it started. And it has evolved over the years. And it was refined by the time we got our constitution. It was now part of our laws, section 3, subsection 1 of the Literature Act, which made it important, made it necessary or imperative that we apply the English common law. It required us to apply equity and statutes of general application. I'm sure you know those things. So it's section 3(1)(c) of the Literature Act. And so the the time the Constitution came in 2010, we had a law that was our guardrail. And the Constitution then came with Article 163(7). It doesn't talk of all the courts, but it says this. All courts, other than the Supreme Court, are bound by the decisions of the Supreme Court. It's as simple as that. All courts below the Supreme Court are bound by the decisions of the Supreme Court. And so, lower courts, from the Court of Appeal all the way to the academic courts, tribunals, they are guided by this. And recently, not quite recently, but one of those cases that we have decided on, still Decisis, is that famous case of Rai versus Rai. And we say that the immediate pragmatic purpose of such an implementation of the judicial process is to ensure predictability, certainty, uniformity, and stability in the application of law. Such institutionalization of the play of the law gives scope for regularity in the governance of commercial and contractual transactions in particular, though the same scheme marks also other spheres of social and economic relations. It is very assuring. It is this very assurance that the law will not keep changing, that the law will not change with the winds of judicial temperament. And yet, Decisis is not without critics. Decisis has also been criticized because it breeds rigidity. When you say you can't move to the left, you can't move to the right, what does that say? It means you can't develop jurisprudence. It perpetuates injustice. So you are following this law, but the result is that somebody is suffering injustice. So although it's a good thing that you are predictable, that you are uniform, but there are also the flip sides of Decisis. So what is the hierarchical structure of the courts? Again, this is very elementary. Hierarchical structure of the courts in Kenya. There are two levels. The broad levels, we have the subordinate courts at the bottom. That's how now they are called under the Constitution. Magistrates courts, cardinals courts, tribunals, small claims courts. Then you have superior courts. So you have subordinate and superior courts. So superior courts are the Supreme Court, Court of Appeal, High Court, and the other two courts, Environment and Land, Employment and Labor Relations courts, or we call status today. So at the summit is the Supreme Court, and then the other courts follow. And so if you remember what I said about Article 163(7), that arrangement where you have the Supreme Court at the summit and then the rest at the bottom. So that's it about the type of the hierarchy of courts and the type of president and dimensions of Decisis. This was the third thing I was going to talk about this afternoon. And so we have understood the structure within which Decisis operates. It's now important in terms of the types of president that courts apply. Not all judicial statements carry the same weight. If you read a judgment of, say, 30 pages, not every statement in that judgment has weight to constitute Decisis. Some of them may be what they call obiter dictum. Some of them may just be, these days, judges like, say, telling stories. They just go on storytelling. And going back to the Bible, the Quran, quoting William Shakespeare, Charles Dickens. So when Charles Dickens is quoted, is that Decisis? So not every statement in a decision forms forms part of the Decisis. So there are distinctions that we must draw of Decisis. The first distinction I want us to draw is a binding president and a persuasive president. So a binding president is one that a court must follow. That's binding. Court of appeal and the courts below it must follow the decision of the Supreme Court because those decisions are binding. By contrast, persuasive president refers to decisions that a court may consider but is not obliged to follow. This may come from courts of coordinated jurisdiction, like High Court and the other two courts of equal status. They are not bound, but they can be persuaded. Even the Supreme Court can be persuaded by a High Court decision. So, and Obita also can be persuasive, but I just said something about Charles Dickens and something else about delay, the dispensation of justice. It can also be persuasive. You can also be persuaded by judgment from other jurisdictions, and there are those who borrow from the Commonwealth. But I see today we are borrowing even from China. Without looking at their constitution or their laws. So long as there is something that is quite attractive in their decisions, we are quick to borrow from Afghanistan. The second distinction I want to draw is between ratio decidendi and obiter dictum. Ratio decidendi, as you all know as lawyers, means the reason for deciding. I have decided this way because of the following. So ratio decidendi constitutes a legal principle or rule upon which the case is decided. For instance, if there's a dispute about ownership of land, and the case is decided that out of the two, one has a forged title deed. So the ratio is the title deed is forged, and therefore he is not the owner of the land against the other owner with the right title. So this is the binding effect that forms a president. And we contrast obiter things that are said as by the way. Yeah, if say I'm writing about football, I'm writing about EPL, for those who love EPL matches. You're writing about Manchester United and City, and you're writing about the performance of a particular match, but you veer off to talk about the car or the cars some of the players drive. About the cars, that is obiter. It's not related to the subject that you are discussing about this particular match, and so that's why it's not binding. It's not a ratio. Another distinction is between vertical and horizontal decisis. Vertical is the one that I gave you from the Supreme Court going down. That is binding. But horizontal decisis is where you are borrowing across. You are coordinated jurisdictions, but you are borrowing the decisions across the board. At the apex court, the Supreme Court has articulated its approach on these matters, so that you recall when I read Article 163.7, I said all courts other than the Supreme Court. The Supreme Court is not bound by its decision. But sometimes we can depart. I don't think we have departed before. First of all, to depart, we need to meet certain very stringent conditions. say this decision was wrongly arrived at, it's very difficult for judges to agree they were wrong. So we are waiting for one day when it will be obviously wrong that we made a wrong decision to see if we can answer. So what are the practical applications of sterile decisis? I just want to give you examples of this, how a sterile decisis has been applied in Kenya, the horizontal application. Ordinarily, a court applying horizontal sterile decisis will follow its own prior decisions, except in very exceptional circumstances. Whereas judgments of higher courts must be followed by a lower court, the decision of a court of concurrent jurisdiction are only persuasive, as I've said, and are not binding. Thus, a coordinate court may depart from such a decision if it considers it wrongly decided. It's easy for the High Court to depart from this previous decision, but not really needing. There must be good ground for departing. And so, in the case of Mohammed Abushiri versus Minister for Lands, a case that was decided in 2015 by the Court of Appeal, this is what the court said. The principle of sterile decisis requires that, although not bound to do so, the court should follow a decision of a judge of equal jurisdiction unless the decision appears to be clearly wrong. Decisions by courts of concurrent jurisdiction are only of persuasive nature and cannot bind the court. Nevertheless, conflicting decisions of concurrent courts have caused confusion. The High Court, in the case right now, I don't know if it's been settled, but when the High Court insisted that when you sue a governor, you must enjoin the deputy governor. And the High Court has gone this way that we don't have to, you have to. So there's total confusion. The other one is on small claims court, that the jurisdiction, and I believe my colleagues here know this, that we haven't settled what small claims court can do and cannot do in certain aspects. We have also had issues to do with jurisdiction of the High Court and Environment and Land Court insofar as mortgages are concerned, where some High Court decisions say mortgages involve money, so that must be the commercial division of the High Court, and some High Court decisions say that mortgage, the baseline is land, is a house, so it has to go to the Land and Environment Court. So those are some areas that cause confusion, and it's not good for growing jurisdiction like ours. And so for ourselves, when there is confusion, I think the courts have decided that in the lower courts, a larger bench is constituted to determine the confusion. So like the Icharia versus Icharia, I don't know if you remember this case on division of matrimonial property upon divorce. And for a while there was confusion. Does the lady or the man get 50% of the property, or does it depend on the contribution of each spouse? Until an enlarged bench of the Court of Appeal settled the matter in the Icharia versus Icharia, that remained an area of confusion. The Supreme Court has also clarified its position in BBI. Also, you will remember the case of BBI. We have also clarified it in Dina management, which is a land matter. And in Dina, we say that the ideal scenario is for trial court judges to follow decisions of other judges of the same court unless the compelling reasons to be acted to ensure consistency, certainty, predictability, and sound judicial administration. The next question under this is whether the High Court and courts of equal status are bound by the decisions of the Court of Appeals. This may sound obvious because of Article Decisis, although Article 163.7 talks of the Supreme Court only, its decisions binding on courts below. There is no similar express provision about the Court of Appeals decision binding the courts below it, or the High Court decision binding the subordinate courts below it. But we go by Section 31C again of the Judicature Act that imported common law practices. Statutory Decisis is a tradition of common law and we can apply it even in the absence of express provision in the Constitution. And this was confirmed many years ago in 1970 in the case of Belgia versus National and previous bank, where they say the courts are strictly bound by the decision. High Court is strictly bound by the decision of the Court of Appeal. And the Court of Appeal has also said this in the Kibaki versus Raila, Kibaki versus Moni. I said Raila first. It's the most common. So it's Kibaki versus Moni, which was in 1999, where it was stressed that the High Court has no powers to overrule or disregard the Court of Appeal. In the National Bank and Wilson Golaya, again this was emphasized, that there is no discretion, that the High Court has no discretion when it comes to binding decisions of the Court of Appeal. And in Nagawambura, the Court of Appeal actually admonished the High Court for not following its previous decisions. And we debated, as I'll be discussing over tape shortly, what to do in the courts that are not following the decision of the Supreme Court in Ruatetu. And so, David Ngera, while he was in the High Court, in the case of the Deposit Protection Fund at Sambian Supermarket, saying that under the doctrine of stare decisis, the High Court is bound by the decision of the Court of Appeal, regardless whether the judge agrees with it or not. So you can simply, if I don't agree, and we did this even as we served in the High Court, in the Court of Appeal, if I don't agree with, say, the Court of Appeal decision, and I'm sitting in the High Court, is to give my view that if I was to decide this case without these chains of stare decisis, I would say the following. So I would be distinguishing the decision that I'm supposed to follow, but end up following it. And so what David Ngera was saying, you really have no discretion, you must follow. But if you have a divergent view on the matter, just say it, because such views, as you recall, people like Rodeni, those are the views that form the law. So express them. Don't say my hands are tied, I can't say anything, I just follow what the Court of Appeal has said. Say it goes, then follow the Court of Appeal. And because of what the Constitution says about the decisions of the Supreme Court, the Supreme Court has said a few times about the way Ruatetu has been misapplied by the courts below, forcing the Supreme Court to issue Ruatetu 2 to try and clarify that Ruatetu 1 was about murder. So applying it in robbery, violence, applying it in sexual offences, applying it in cases of under the Forest Act, that was not intended. And we are saying that we are ready as a court the day you will bring an appeal to say that the minimum mandatory sentences under the Sexual Offences Act are unconstitutional, we will consider that. But recently we got one from the hearing. It was properly balanced. But again, it was not properly presented. The Court of Appeal, not being a trial court, simply looked in a courtroom. We have a case here. So who is the lawyer who can present? And then we are told, they argue this way, because so that we will take it and be addressed by the Supreme Court. So when it came, we said this has to start from the trial court. It has to come to the High Court. Let it be raised as a constitutional issue. But a Court of Appeal can't start it at that level, where the High Court has not given its view. So we are still waiting for the right moment for us to say that if you are caught with chattel, those minimum sentences are unconstitutional. If you are convicted and sentenced under the Sexual Offences Act, then those sentences are unconstitutional. So we are still waiting. And to make it worse, of course, you know how this was abused in Muwachetu 1. I'm not quite sure whether Muwachetu 2 is being abused. But Muwachetu 1, I mean, even magistrates were able to pass sentences where they had no jurisdiction. People have come for resentencing. So it was a free-for-all. It became necessary that the Supreme Court clarify it. It went to the point where a court, I think it was a Court of Appeal, yes, in the case of William Nkumba, and said, I think it was Ontario, where the Court of Appeal went as far as defining what a life sentence is. So that if you are sentenced to a life imprisonment, the Court of Appeal said that means 30 years. We just speak from that. And when we were correcting it in the Supreme Court, we said you can never get involved in the legislative process. If Parliament and Kenyans want to define life sentence between 30 or even 2 years, it can be for us. But of course we are being criticized for stifling progressive thinking by the judges below, but that's really not true. Can the Supreme Court depart from its own decision? Our situation is very unique. While the Supreme Court decision binds other courts, it does not bind the Supreme Court, meaning the Supreme Court can depart. But as I said earlier, it's not a very easy process for the Supreme Court to depart. You have to bring a separate application. It's not just something you can argue in the course of your appeal. You have to bring a specific application which the other side will agree with or not agree with. And so we are not bound, but we never departed. People try to come for review. They don't tell us to depart. They say, no, you did not get this one right, but review is allowed also in our rules. But again, this is like passing through an eye of a needle. To get a review is really just to be a clerical error, something that is so obvious on the face of our record. But you can't tell us in detail that, last year this was the decision, now you say this. Those who will dismiss with a ruling of half a page. So circumstances warranting departure, generally not just the Supreme Court. And how does the Court of Appeal, High Court, even if it's horizontal circumstances, how do we depart? What makes the course of that? The course will depart to prevent injustice. If followed a decision that was decided earlier is occasion injustice, then we must think about. If the realities have changed in that area of law, we must, even the law may have been changed, we must change our approach. And where the facts presented are materially different, again, you can distinguish and move on. The second ground for departure is where the earlier decision was made in curia. Of course, we all know what that means. It was made in ignorance of the law, it was made in ignorance of previous decisions, and so you can depart. Like in the case of Joseph Kibuna, the Court of Appeal said this decision, the earlier decision in Profegoto, Tiso was made in Curia, or where something was overlooked. And I've talked about confusion in the courts where we have different decisions on the same subject matter. If that decision or confusion is caused at the level of, say, the Supreme Court, or at the level of the Court of Appeal, how are the subordinate courts, the courts below the superior courts, supposed to behave? They have a choice. If you have three decisions going different ways, as a magistrate, you can choose. And you are allowed to, because then what is binding you? All of them are binding you. So pick one and move on. As I get very close to the end, I'm dumping some areas. So what's the relevance of stare decisis? Today, what is the relevance? The Constitution 2010 marked a turning point in our judicial system. The Constitution has been praised as very progressive, and so as we discuss stare decisis, can we say that we can still progress under the new Constitution that is progressive, while at the same time retaining the traditional requirements of stare decisis? Can we respect decisions that are not progressive under a progressive Constitution? So these questions are important. How should judges remain faithful to President while also advancing transformative social order that may compel them to move beyond or even overturn establishments? Article 159(2), justice must be administered without undue regard to procedural technicalities. This encourages judges and judicial officers to be flexible as they make their decisions. Article 20, courts are empowered to interpret the Bill of Rights in a manner that maximizes protection of rights and freedoms. Again, expanding the areas of judicial decision. Article 2.4, any law or conduct inconsistent with the Constitution is invalid, including a bad president. Article 10, national values such as equity, inclusiveness, human dignity, social justice must guide our judicial decisions. Together, these provisions affirm that stare decisis cannot be applied mechanically. We cannot today simply say that in Yella versus Passman Brown, this is what we say. And we've been criticized that decisions that were made in Lillian S, we've never tried to improve. When there were three conditions to be satisfied, they remained three. We never tried to add a fourth one. How then do we progress? So court therefore must interrogate whether past decisions remain relevant today under the new constitution. It's no longer that still called the new. The judiciary is increasingly getting tasked with striking a careful balance between legal stability, Decisis, and making progressive jurisprudence. The President is no longer viewed as an unlimited command, but a guiding principle. In conclusion, to have certainty in the application of the law, presidents must be followed. This is not only in line with the doctrine of Decisis, but also fundamentally is a constitutional obligation under Article 163(7), pursuant to which the Supreme Court has the final say. Failure to adhere to President by the superior courts may disrupt the uniformity, consistency, and predictability of decisions. And so, Decisis, good thing, helps us, makes our work very easy. If you are a judge and you're writing a judgment, it's so easy to just go to a decision that was made 7-8 years ago and just import the decision into your decision, and you are good to go. But things have changed. As I said, as judges, we are reflecting on whether or not we continue applying these old traditions while we operate under the 2010 Constitution. I think this lecture should have been for judges, because they are the ones who do not keep to the guardrails. But I believe as students, as lecturers, I believe some of these you can borrow in your academic life. And I hope what I've told you today will be useful to your academic life.
I think that clap is not enough for my Lord. Can you do it once again? Once again. Thank you so much. We can have our seats. My Lord, we are grateful that I've had a chance today, a very golden chance, to sit and listen, I would say, from the oasis of wisdom, those who are old enough in this fraternity. We know, my Lord, from the days of him being a judge to the registrar, and it's someone we've admired. And I believe even the young professionals that are in this house, this afternoon, they can agree with us that the nod given by the then president for you to be a judge, we can see great jurisprudence in you, and we are very grateful. At this time, my Lord, it's our tradition in this campus that after every talk, our students who are very bright, and as you heard, even Madam Chief Magistrate could affirm this, when we sent them to court, they proved that those others, they are number 2. So we are always leading. And I know these students want to prove it to you today. They have so many questions. And the nature of our students, my Lord, is they can even ask you on the judgments you've written, even the one you wrote yesterday. They have that. Madam Chief Magistrate knows when Judge Moredi came here, every student stood to ask questions concerning the judgment that he wrote. And I think he was almost forced to depart from some decision, but nevertheless, all went well. So you're going to have questions. Please let's limit them to the topic of the day. I know someone wanted to ask about the patience of my Lord when the song was sung, Piki Piki Ponki, before you. So please don't ask those are obiter today. Let's go straight to the questions. However, before we go to the questions, I see we have so many people who have attended this talk. Some of them are not from the School of Law, and we really appreciate. Let's appreciate those who have attended today. My Lord, you can see we even have an overflow. That tells you that we are waiting for you. Very fast, allow me, my Lord, to introduce the School of Law, and then I'll introduce the rest, and I'll do it with less than 2 minutes because of time. At this time, I want to ask the Dean, School of Law, to stand and wave because it is known we are not going to give him a chance to talk. That's our Dean. Let's appreciate him. We have our chair, our able chair who is with us. Let's also appreciate him as he stands to wave. We have our able lecturers who interact with these students every day. I would request them to stand and wave. Lecturers. We have management with us. These are the opportunities when we meet the management. I know the DVC was introduced, but I can see we have our registrar with us, and any other top management, we have also our deputy registrar. Please, let's appreciate them also as the greeters. These are our top management. We have staff members who are not from the School of Law, and they have joined us. Please, if you're here, please stand and wave to us. Staff who are not members of this, let's appreciate them. Thank you so much for joining us. We could be having students who are not from this school. I know they are here. Let's also appreciate them. Please, where you are, stand. We appreciate you. Students who are not members, I see some of them. I'm tempted to call them by names. Please, if you're here, stand. Okay, they are shy because of the Latin language that we just heard. In our school, we have various groups and various clubs, and I know we have leaders with us. I would request, I know these people are always expectant with information. They like talking, but for this session, I would ask them, all leaders of clubs and associations that we have from our school, please stand where you are. We appreciate you. And also class representatives. Yes, there's all over. Let's appreciate them. My Lord, you can see we are mentoring young leaders. And so when you see us at the Supreme Court, just know we've gone through the system and we are there. I believe we've introduced everyone. I know we have others who are doing support work, but we really appreciate you. At this time, I want us to have questions, and time is so much limited. Please go to the question. Stop doing the introduction to the question. Just go direct to what? To the question. I would request my able dean reminds me it's one question.